What's going on, everybody? This is Lady Luck here again. How's everybody doing? I understand that I have not been live in a couple days, but don't worry. There are plenty of videos that have premiered today, well, technically Friday, and also that have been posted for you guys to check out for your viewing pleasure. So please make sure you check out all of the great content that was released, either premiered or just posted. Make sure you have your notifications turned on to receive all notifications from the Lady Luck Club. And make sure you guys hit the like button. If you have not subscribed to the Lady Luck Club, you must subscribe. We're going to have fun. And we get out the facts here. And then also consider sharing the information out and becoming a member of the LLC. We have a great live stream for the members only scheduled for tomorrow night. We're going to try to do like a mock trial type of game. And of course, we're going to get back to our Spanish lessons. So consider becoming a member and share the content. Now, I believe this particular video, this is definitely a hot topic since Candace Owens has decided to release, a screenshot of an EMR with Charlie Kirk's information, his hospital information rather, on it. So I received a comment, and I think it was just a legitimate comment that kind of sparked me to want to do a little bit more research regarding HIPAA privacy laws and journalists or, news press members releasing information. And so I want to just show the information that I've researched and discovered so far. And of course, there is a relative case that a ruling was given concerning the release of or publication of patient information with the news media that was recording a scene for a show inside of a hospital. And patient information was released while that so-called screening or recording was going on in the hospital. So that's the closest case that I could come across that it relates to some level of tort caused by the release of patient health information from a member of the news media. And we got to start off with what exactly is Candace Owens considering herself to be here? Because I'm going to tell you right now, I can't, after this whole fiasco with her relentless reporting on this Charlie Kirk and all the conspiracy theories and leading to, Jewish conservatives being threatened by lunatics that are listening to Candace Owens. And additionally, the fact that she really has not produced any documented evidence that could actually hold weight in the court of law. No one cares about her conspiracy theories on a social media platform. What type of evidence has she produced that would be admissible, viable evidence used in the court of law pertaining to Charlie Kirk's assassination? And so a lot of people don't understand. You're really, talking about a particular topic, a subject, and then you go into the realm of private information, whether it be finances or medical information. You have to understand the law, and you need to be careful about what you release. That's just maintaining some level of integrity here. I don't personally consider Candace Owens to be a journalist, by no means. But if she, let's say, gets a lawsuit, and she considers herself to be a member of the press or a journalist, just like she's trying to do with the Macron lawsuit, then you're talking about having to meet a certain, parameter or prerequisites when it comes to what's considered to be defamatory or tort or a release of, private health or medical information. So I want to just kind of go over the information that I've come across so far with you all. And I'm going to read over this, and I always challenge people to go behind me and do some reading and researching for yourselves. But understanding the law and the rights protections of, you know, any person in general, but particularly pertaining to medical information, is vital if you're going to sit and report and talk about these things. So I simply did a Google search. I mean, it's just that simple. And this is a document from the Davis Wright Tremaine LLP. It's a law firm where they kind of go over and speak on, HIPAA privacy laws and what members of the press are held against when it comes to the laws and the responsibility that they have in their journalism. So, you guys, I will have this link in the description of the video for you guys. All the resources, I always put the links of information that I, you know, come across and share with you all in my research. I always have the links in the descriptions of the video. So you guys make sure you check that out to get the links to this information so that you can read it for yourself. And of course, when it comes down to a matter of law and understanding and interpreting the law correctly, consult with an attorney. Okay. It's okay to ask an attorney questions in general. Some will even give you like a free consult just so you can have a better understanding. But what we're reading here is, and I'm not going to read the whole thing, it's 16 pages long, but I am going to go over some of this information that they speak to regarding, you know, the liability that journalists, I consider myself to be an independent journalist, the liability that we have when we're doing our reporting. So let's start with the basic statutory prohibition. Both HIPAA and the CMIA prohibit the dissemination of individually identifiable health/medical information without authorization, except as specifically required or permitted by those laws. So state laws vary, and some states have certain restrictions and parameters to which they consider to be protected when it comes to journalism regarding the dissemination of medical or health information. But as you can see, they're specifically speaking to the individual identifiable health medical information. When Candace Owens posted up that medical file, it was a screenshot of an EMR showing that Charlie Kirk had been seen or had been a patient of a hospital after he was shot. That released information where you could clearly see who the patient was. It had his name, it had his date of birth, it had a couple other identifiers that are, specific to that software program that they use. And of course, it showed the date and time. Now, that's not typical for a journalist to release information like that. And I think it's reckless because what point are you proving other than he went to this hospital? But it has nothing to do with whether or not this hospital had any, participation or played a role in the actual assassination of Charlie Kirk. This is all because Candace Owens is just making assumptions and questioning everything. Even things that, are clear documented in evidence that are not logical or reasonable. It's everything is now just a conspiracy theory. And because of that, someone from the hospital took a print screenshot of the patient log of patients that had came into the hospital for treatment, and they emailed it to her. And they did this without written consent from seeing that Charlie Kirk is deceased, from the next of kin. That would be the one that would have the legal authority to give consent regarding a release of her now deceased husband's information, medical information. And she did not obtain any consent to post that information up either. So the medical staff violated HIPAA privacy laws because they work at the hospital and they had no consent to send a print screenshot of anything concerning Charlie Kirk's health or medical information. And then additionally, emailed it to Candace Owens, who also failed to obtain consent. So, as you can see here, this prohibition applies to information about deceased persons as well as living persons. So there's no exception to that. Just because Charlie Kirk passed away does not mean that she or anyone else has the right to post up individually identifiable health or medical information without authorization about Charlie Kirk. You would have to go to the next of kin, that being Erika Kirk. And for some reason, Candace Owens forgets that she's not Erika Kirk. So, do HIPAA and CMIA apply to journalists? Neither HIPAA nor the CMIA expressly applies to journalists. These laws expressly prohibit the unauthorized disclosure of individually identifiable health information by healthcare providers like doctors, dentists, psychologists, psychiatrists, etc., and other healthcare entities such as health insurers and certain handlers of health care data. However, because there's always a however, the CMIA also prohibits the further dissemination of personally identifiable medical information. The exact scope of this additional prohibition is unclear, even though I have now a case that I will show you all that comes close to interpreting this language here when it comes to any member of the media doing any publication of said health medical information without consent. So even the HIPAA does not apply to the media. Journalists must be, even though HIPAA does not apply to the media, journalists must be equipped to deal with and perhaps question the manner in which covered entities interpret HIPAA's prohibitions. So there's been no criminal prosecutions where a media member of the press, a journalist, was the defendant under HIPAA or the CMIA. Now, this, and I have to, in all fairness, consider when this was written or published, this actual document here. Because, like I said, there is a case now that has shown that there was tort where the petitioner won the case, basically. And damages incurred because the news media decided to film for a show inside of a hospital where patients' personal identifiable health information was released during that filming. So whether you're recording inside of a hospital or you're sitting on YouTube, pulling up PowerPoint presentations, it still deals with publication. Publication is just simply the release of the information itself. So no different than the media recording for a show in the hospital, Candace Owens disseminated this medical health information regarding Charlie Kirk. She published this information in a video on social media without consent. So I want to say that this document is fairly new, but don't quote me on that. But either way, like I said, there's some information in the case that I'm going to pull up and show you all, because it still applies to the larger topic of it being, some damage that could be incurred with the release of that information itself without consent. Why would she not just get consent? Candace, you're reckless. You're absolutely reckless. So, however, as you guys can see here, in a civil case where the CMIA was not directly in issue, the California Supreme Court allowed an intrusion privacy tort claim against media defendants to be heard by a jury, stating in a footnote in its opinion that the question whether the media defendants acted in concert with Mercy Air to illegally, in violation of the CMIA, reveal confidential medical information may be relevant to plaintiff's intrusion claim. So that means basically the media came in and intruded upon the patient's health information by releasing it. Also, there has been one California civil case where the appellate court, in an unpublished opinion, assumed the CMIA applied to a network. The court held that the network had not disclosed information in violation of the statute, but as in the case mentioned above, and they're referring to this case here from the California Supreme Court regarding the intrusion privacy tort claim, as mentioned in the case above, the court allowed intrusion claims to proceed. So Candace Owens could be sued with a civil, it's lawsuits, a civil proceeding for intrusion claims. And tort basically is just damages that you incurred. So the videographer in that case had been dressed in hospital attire and had told the plaintiff that the film of his hospital emergency room evaluation and treatment, which subsequently was broadcast, and another word for that is published, would be used only for training of hospital personnel. So the pretenses to which the media stated that the recording was being done for was false. They told, I guess they told the hospital, hey, we're doing this for a show, or we're doing this for our hospital, training personnel, so to speak. And that wasn't the case. And then it was released out to the public. So it wasn't kept and maintained within the hospital itself to be used only for the training of hospital personnel. It was broadcast out to the general public. That is the problem. And that's what Candace Owens did. So we have what they're defining to be individually identifiable health information under HIPAA is a subset of the larger category of health information and is one, created or received by a healthcare provider, health plan, or healthcare clearinghouse, and two, relates to the past, present, or future physical or mental health or condition of an individual, the provision of healthcare to an individual, or the past, present, or future payment for the provision of healthcare to an individual. So, of course, if a health insurance company released this information, beyond what they are legally entitled to obtain in order to remit payment for treatment or care, that would be a violation of HIPAA. They are considered, like the doctors, healthcare insurance companies, others that are specifically tasked to maintain healthcare data, are considered covered entities. So they would be held against HIPAA privacy laws. So we're going to go down, and now we're going to talk about individual identifiable medical information under the CMIA. And under the CMIA, medical information is information in possession of or derived from a provider of healthcare, health plan, pharmaceutical company, or healthcare contractor, such as a pharmacy benefits manager, regarding a patient's medical history, mental or physical condition, or treatment, which one includes or contains any element of personal identifying information sufficient to allow identification of the individual. So when Candace posted that screenshot that a medical staff emailed to her without consent, and then she published it without consent, we could clearly see that the patient's name and date of birth was on that screenshot. It wasn't as if she was speaking of, let's say there was a health scare where people were getting sick from taking, just over the counter prescription medication. And she's speaking on just a general awareness to the public of hey, y'all might want to be careful when y'all take this prescription medication because this hospital has reported that it's received like 50 cases within 2 weeks because people are coming in and they're getting sick. And the common factor in this is this specific prescription medication. That is bringing awareness to the public that the public would have interest in and have the right to know about. So under that, that's considered journalism. You're talking about information that is of public interest, basically. And I see it as this, when I do research and reporting, I'm researching and reporting information that I feel that the public has the right to know. But that also helps me to understand what I do and do not need to report and release to the public. I do not ever need to release someone's medical information. Now, if I want to give an alert or say, hey, you guys need to be aware that there's a recall on baby formula, I don't need to release the names of the patients or the babies that are being treated because of the recall of baby formula. All I need to do is speak on the danger of this recall baby formula and for parents to be careful and to not purchase this formula to prevent their babies from getting sick. Talking about that does not mean I need to release the names of the babies that are being treated in a hospital, because that is individual identifiable information. And it will be clear that you're speaking of a specific patient. So, and this, of course, leads to number 2, includes or contains any information that alone or in combination with other publicly available information reveals the individual's identity. There was no mistake in Charlie Kirk's name and date of birth being shown on that medical file that Candace Owens published on her platform. No one walked away confused at who she was talking about. His name and date of birth were clearly shown on that medical file. So I just want to scroll down and speak on some of the information here. Impact on news reporting. As previously mentioned, the prohibitions on dissemination of medical information might initially appear to govern only disclosure of personally identifiable medical info by healthcare professionals, but that impression is deceiving. The CMIA, for example, also explicitly regulates redisclosure by recipients of individually identifiable medical info. Importantly, the term recipient is not defined in the statute, so creative plaintiffs' lawyers may claim it covers anyone, since it's not being specific, anyone who received individually identifiable medical information, including journalists. With the exception of the cases cited above, however, and they have endnotes or footnotes at the bottom, it appears that this has not been occurring so far. So I want to go over to this next article here, which kind of helps to give a better breakdown regarding HIPAA privacy. And this is also from a law firm, it's Law Shun. And the web address, the web link to this article will be in the description of the video. So, of course, they reiterate HIPAA laws don't directly apply to journalists. There are 2 scenarios in which they may become applicable. If there was a wrongful act in obtaining an individual's healthcare information, or if state law barriers are in place. The Constitution has given states the authority to create state statutes. It should not be deemed unconstitutional, however. So that means the state law cannot contradict or undo constitutional law. So as long as it's not contradicting constitutional law, then the individual states have the right to create, state statutes, state law, to ensure that additional protection is provided. HIPAA privacy laws are federal laws, But state laws can help to define even more or provide additional restrictions or prohibitions on what is released or considered to be protected for that specific state. HIPAA protects private healthcare information from being released to the public without consent. And several courts have stated that publishing medical information without consent is offensive and not newsworthy. It is never necessary to show a medical file for any person, alive or deceased, in order to bring awareness about an outbreak of salmonella because of tainted eggs. See, that's what and when you're, as a journalist, when you're reporting this information, asking, is this something that the public needs to know, always helps you to understand the integrity in your reporting and not releasing information that it's not really necessary. Public doesn't need to know specific patient health information of someone else. Why? And if we all have the right to privacy and have the right to be assured that we have protections safeguarding us when it comes to our medical information, then who is Candace Owens to release it without consent? So let's go to the first scenario here that they speak of. If there was a wrongful act in obtaining an individual's healthcare information, stop right there. The medical staff that took the print screenshot of that medical file for Charlie Kirk just to prove, oh, he came to this hospital, did not obtain consent from the next kin of Charlie Kirk or any family for that matter. And the next kin would fall in like a succession. So I'm sure Charlie Kirk had a living, a will in place, perhaps even a medical advance directive of some sort, which outlines the treatment and care should the patient become, unable to make their own decisions. So if, let's say, he was shot, but then he went into a coma, he would not have the mental capacity or the mental competency to actually consent to release of medical information. And so a medical advance, like some sort of advance directive or a medical directive, would outline who would be responsible for making those medical decisions in the event the patient is unable to do so on their own. If he had a will, more than likely, he would allow that consent to flow to his spouse because he was married. If he was not married, perhaps the next of kin would flow to the parents. If the parents are deceased, then that next of kin will flow to the next oldest sibling, and so forth and so on. So that's kind of typical how the hospital can, deems who's next of kin, or how they, identify next of kin in the event that a patient is unable to make those decisions, or, of course, if they're deceased. So those are the questions that are typically asked. Okay, well, was the person married? If not, are their parents around or alive? Okay, do they have a sibling? Did they have anyone in place or appointed to ensure that in the event of an untimely death, that there's someone that can make final decisions regarding any medical treatment, any life-saving measures, whether or not the patient is an organ donor, all of those things would fall upon whomever is designated to make those decisions. In this situation, it will be Erika Kirk once again. Therefore, journalists must obtain consent before publishing an individual's medical information to avoid being held liable for the publication of private facts. That print screenshot was a fact that Charlie Kirk had been seen in that hospital. But was it something that the public needed to know? And the question would be, if you get these candy asses conspiracy theorists out here saying, yeah, we needed to know that. Then why? Because all that did was just show that he went to the hospital. How does that have anything to do with the actual assassination? It has no direct link or correlation. And when I say that direct link or correlation, I mean based on the actual screenshot itself. Would that make a case in the court of law to a judge or jury that this is material evidence that would point to direct correlation between Charlie Kirk going to this hospital, the hospital itself, and the question as to who either aided in the assassination of Charlie Kirk or is directly responsible? That screenshot did not do that. It did not support any of her theories about the hospital being in on it. No more than her releasing the information of the hospital staff, the doctors, the surgeons, and then you have a medical staff that decides, I'm going to take a print screenshot of this and I'm going to send it to Candace Owens without consent of the patient or the next of kin for the patient. So this is right here, even though she might not be able to be criminally charged as, I don't consider her to be a journalist, but whatever. She could still be held liable for damages. So Erika Kirk, if she wanted to, can still file a civil lawsuit and a complaint. File a complaint with the Health and Human Services OCR. So either way, Candace should be asked a lot of questions and forced to answer because she didn't have consent to post that information up, to disseminate that information, to publish that information in a video on a social media platform that is being released to the general public. So they have it here, a chart table that I think is easy and necessary for those who either, want to sit here and talk about, oh, Lady Luck Club, you don't know what you're talking about. Okay. Well, talk to an attorney. Challenge me on that. And it says here, I'm not saying information to fit a point. I'm releasing all the information in fairness. Does HIPAA apply to journalists? No, HIPAA does not directly apply to journalists. When does HIPAA apply to journalists? In two scenarios. When they say directly, meaning they're not considered a covered entity. So Candace Owens is not a doctor, nor does she work for the health insurance company processing Charlie Kirk's claims to pay out any medical bills or expenses, nor is she, the pharmacist that's trying to get, prescription medications for anyone. She's not considered a covered entity. If she's going to consider herself to be a journalist, though, however, in these scenarios, this is where the journalist would be held liable for the information they release. In two scenarios, if there was a wrongful act in obtaining an individual's healthcare info or state law barriers, how does HIPAA apply to journalists? Journalists likely violate HIPAA, and you see the wording here, likely violate HIPAA if they obtain and disclose healthcare information through false pretenses, misrepresentation, or fraud. Candace is doing this under a false pretense. She's trying to say this hospital has some sort of direct correlation to the assassination of Charlie Kirk. And the hospital has nothing to do with that. They see thousands of patients a day. How do you say, out of all the patients, the hospital somehow is involved in the death of this one patient because reasons? He was seen here. She did not obtain authorization from Erika Kirk. It was not her place to release that information. And Candace is overstepping her boundaries. She was not his wife. Journalists have a duty to be rigorous and robust in their investigations. Yes, we do. But they must also respect people's privacy, common sense. This includes anything that a person might reasonably expect. Y'all see this wording here? If you file a civil lawsuit against someone, the burden to meet is the preponderance of the evidence. You just need to be 51% convincing. And that 51% convincing is based upon what the average person would reasonably expect to keep from becoming public knowledge, such as medical information. I would never consider Charlie Kirk's medical file or that print screenshot that was sent illegally to Candace Owens without authorization or consent to be something that I would need to know in order to research information about his assassination. No one needed to know that, because that information didn't lead to anything. It didn't bring forth a viable suspect outside of Tyler James Robinson. It did not resolve the question that I have personally about how a gun got on the roof when it was not captured in the videos according to the probable cause affidavit that was signed by the court. It didn't answer those questions regarding, reasonable questions regarding if there were any other persons involved in Charlie Kirk's assassination. That screenshot did nothing. Nothing came out of that. And the average person would reasonably expect medical information to remain confidential, just like his autopsy report. As much as I would love to see a report on that, I have to understand that that is not something that is released to the public. Now, the autopsy could be spoken about or reported on in general terms, meaning an autopsy report is adding to your reporting if you're speaking of just a general public awareness. Let's say it's discovered that certain bullets explode upon impact, and you want to specifically talk about exactly how that bullet explodes and the damages it caused inside of the body. You can say there are 3 autopsy reports of patients where it was lodged in, let's say the femur. And not only did it explode, but it shattered the femur bone. I don't have to say who the patients are, but in general terms, I'm speaking of what was shown or what was reported on the autopsy report. Do I need to sit here and say, here are the patient's names? No. But that would only enhance the awareness of the damage that certain bullets can do upon impact if it explodes. That's the whole point of what you feel or what the public would show some interest in, or just downright need to know. What would be deemed information that the public have the right to know? Me knowing the patient's names and date of birth, or some medical file screenshot of an EMR proving that this person went to a hospital, it's not something I need to know to determine whether or not, if you eat a raw egg and it has salmonella in it, that you could possibly get sick. It doesn't speak to the overall issue that you're addressing to the public that would be of the public's interest. So it wasn't worth her releasing that information without consent, and the fact that she obtained it illegally was certainly not worth her releasing it, because the medical staff didn't obtain consent, and they should not have taken the screenshot anyway. Why would they need to do that? So in the U.S., HIPAA establishes federal standards that protect sensitive health info from disclosure without a patient's consent, because it's all about consent and authorization. HIPAA prevents the publication of medical information, and FERPA, the Family Educational Rights and Privacy Act, prevents the publication of student education records. So I just want to come down here. It gives an example here. If a journalist obtains consent from an interviewee to publish their medical or private info, privacy laws like HIPAA and FERPA do not prevent the journalist from publishing that info if they're obtaining it from an interviewee, and that interviewee's medical private information is being shared with this journalist. That means that this interviewee, i.e. the patient, is giving that consent. However, it is important to note that publication of sensitive information can still cause harm to the interviewee and their family. Before publishing sensitive info, journalists should consider the potential impact on the interviewee and seek consent from them. Charlie Kirk was not alive at the time. Candace Owens was illegally sent this medical file and published it in her video. She did not obtain consent from the next of kin. She never had consent to release his medical information. Never. It is recommended to obtain written consent, especially if the interview is a minor, in which case consent from a parent or guardian is also advisable. Additionally, journalists should be mindful of the form in which the information will be published. Candace Owens has a large platform on YouTube with over 5 million subscribers. So when she reports on information, especially with her here obsessing over Charlie Kirk and still providing zero evidence that will be viable in a court of law, her information is widespread. It has a huge impact, which means it also could cause bigger damages, thereby increasing the likelihood of Erika Kirk winning a tort claim against her. For example, a school newspaper can be a non-public forum, giving the school authority to regulate content and block stories it deems inappropriate, even with the interviewee's consent. However, Charlie Kirk's information was released and published on a platform to the general public without consent. So let me go down, and like I said, I want you guys to read this information. I challenge anyone to do some research and reporting, or just research and read information for yourself. Each state is different. The thing is, with this particular situation, Candace Owens published this information electronically on social media. She might reside in the state of Tennessee, I think, but the medical information came from the state of Utah. So the state law that would apply would be whatever the laws are in the state of Utah, because that is the hospital where Charlie was seen, and that is the information, the state where the medical information was stored. It was housed in a EMR software program that belonged to this hospital, or that this hospital utilizes in the state of Utah. So whatever specific statutes regarding the restrictions or prohibitions of that medical information would be applied. It would apply from the state of Utah, not Tennessee. If there was wrongful act in obtaining an individual's healthcare information, a journalist likely violates HIPAA if they obtain and disclose health information through false pretenses, misrepresentation, or fraud. Just on this alone, clearly, Candace Owens does not have the logic God gave a billy goat to vet her information or tips whatsoever. She doesn't vet it. It's almost like she takes the wildest conspiracy theories and she speaks on that. But facts like this, Candace, facts like this, you omit. Or perhaps you should denounce, Nicholas Ray, who sent out death threats, listening to you and a neo-Nazi. When is that going to happen? Now, okay. So this is what the scenario was for Candace. She obtained it illegally from the medical staff, who should be fired, and they should be charged and sued. And then she published it on a very large public platform to the general public without consent as well, which would make her liable for damages. Erika Kirk could sue her, and she probably would win. I believe she would definitely meet her burden to win. That's just my opinion in that. Erika Kirk would definitely have a case. So you guys make sure you read through this information. And, like I said, specifically the Utah state laws regarding CMIA or HIPAA privacy, as far as releasing of that medical information and the restrictions or prohibitions on it, please read the Utah state law, because that's where the hospital is located. This is another article I came across here at healthcareindustry.news. See, this is what researching does, Candace. You're researching, you provide not just one source, but two, three other additional sources to corroborate the information. And you see that it's all consistent. This is what are the guidelines for media coverage that avoids HIPAA violations. So, of course, media outlets should ensure that they don't disclose individually identifiable health information without obtaining explicit patient consent, avoid discussing specific cases in a way that could lead to patient information, rely on aggravated and de-identified data, we're presenting statistics, and prioritize educational and informative content over sensationalism or voyeurism. Candace, you're sensationalizing Charlie Kirk's death. We all see that. This is what? The 7th week she has been talking about this, where she still has not produced tangible evidence. Candace Owens, what is UTC? What does that mean? Because I don't think you still understand it. You can't make this stuff up. When you don't understand what UTC abbreviation stands for, I can't take you seriously when you're sitting here releasing medical information about a patient that's deceased, where you still did not obtain consent from the next of kin, his wife. Why won't you have Erika Kirk on your show again, Candace Owens? I'm just asking questions here. I'm just asking questions. So since she decided I'm not going to be educational or informative, I'm going to be purely speculative. None of this shit that she's saying is going to be valuable in the court of law. And if anything, it's going to tank the jury. And she's just simply releasing it to release it because she's thinking she's proving a point by saying, oh, look what I was able to get. Yeah, okay, now you're talking about people bankrupting you, Candace. You're setting yourself up to be bankrupted. This is all your fault. No one told you to show that medical file. What you should have done, Candace Owens, is reported the medical staff that sent it to you. And then you let the hospital discipline her however they would. More than likely, she would have been fired. But now look what happened. Not only does that medical staff still have a chance of being fired and sued, now you, Candace Owens, could be sued. And you would lose badly. And I'm talking about millions of dollars here. Because your publication of that information was widespread. You have over 5 million subscribers on your YouTube channel. That's not including what she has on Twitter X. And the fact that her information is reported and is being nationally reported on and talked about, even internationally. She's got a whole president of another country suing her for defamation. Candace thinks that she can act without retribution, without any regard or consequence to violation of laws. She does not have the consent or the legal standing or authority to release any medical information regarding Charlie Kirk. If she understands that when it comes to his autopsy report, why would she still release this medical file, a screenshot of that EMR, just to prove he went to this hospital? That proved nothing regarding the assassination. So Erika Kirk needs to sue her ass, sue her for millions of dollars. Because at some point, Candace Owens has got to learn. And how else does she understand the consequences of her actions if no one does anything? She has doxed people, subjected people to being cyber harassed. That includes cyberbullying, cyber stalking, and of course the doxing. And of course, having to go out and worry about their family members. Phil Lyman had to have someone speak to his character. Because once Candace Owens said his name and said something suspicious about that, then he was like a target. And he caught it for no reason. She's going after anyone that's connected to Charlie Kirk's death. And it's not justified, nor is it logical or reasonable according to any standard in the court of law. And it's unnecessary. You can have questions about the assassination without sitting here and showing names and photos and going out here doxing people, subjecting people to being cyber harassed and bullied, to receive death threats. You don't, none of your reporting should lead to those outcomes, but it does with Candace Owens. At what point does someone tell her, stop, and you need to reel it in? Because now she's already released the information. She can't go. What is she going to say if she does get sued? How are you going to explain this to a judge, Candace? Because you got a whole team that could have been researching the laws regarding the release of private medical information or individual identifiable personal or medical information. And they failed to research this. None of you all over there, Candace Owens, LLC, could bother with researching this stuff before she posted it up. None of you. Ignorance of the law is not a defense, Candace Owens. You can't just say, oh, I didn't know. Nope. You're already being sued for defamation. And then you keep doubling down on that dumb shit with no scientific evidence to prove someone was born a man. This is what happens when you sensationalize the death of someone that people should be mourning. You're not even allowing his wife, his children, his parents, Turning Point USA, you're not even allowing them to just mourn. They're having to respond to you on dumb shit, which to which I said they need to stop doing. Stop responding to Candace Owens, Turning Point USA. You don't owe her an explanation. People are only relevant when people give them relevancy. I'm pointing out the danger of what she's doing. And I am going to report on it. And I'm going to keep my foot on her neck until she learns this lesson. Whether it be the easy way or the hard way, it's up to Candace Owens. But if Erika Kirk wanted to sue, she would have a case. I don't care about the candy asses. They don't read shit. But she has no right to release Charlie Kirk's medical information. None. She has not received any consent whatsoever. And you're talking about all of this coming from someone who can't define the words nationalism or define what UTC stands for. Why didn't you research that and Google it, Candace? You nor your team that you have, that you are hired, I'm sure that you're paying, bothered to research UTC? Really? Whose fault is it that you did not understand that abbreviation? They should try to brush it off like, oh, it's no big deal. It is a big deal if you're going to sit here and report on it. That's part of the research that you should be doing, Candace. Not just saying things because, it's sensationalism. And no judge will even take your dumb excuse for a viable legal argument. You're not really doing anything other than just talking about it. And you're pushing everyone else away. Girl, if you don't go somewhere, sit down. It's so crazy. So you guys can see the information here. It goes over HIPAA. It goes over the primary focuses in the healthcare entities that are bound by the law itself, that medical staff being included. So this content here, this article, the link will be in the description. I mean, I can show information for days. This is called research, Candace. Here you have another law firm, Holland and Hart, HIPAA and disclosure to media. And then, of course, they speak. The first thing they do is speak of these two cases here that are relevant, that would help to set some sort of standard as to how HIPAA or the CMIA laws are being utilized when it comes to members of the press or the media. And so these two cases here, and if you guys, this link will be in the description. If you click here, there's a hyperlink and it takes you to the information on both of these cases. So Texas Health System agreed to pay a $2.4 million HIPAA settlement arising out of a hospital's disclosure of a patient's name in a press release. And then you can click on that information here. Last year, when was this published? In 2017. Okay, so last year, 2016, a New York hospital agreed to pay $2.2 million for allowing media to film in its facilities. Given these cases, it is a good time to review the HIPAA rules and disclosures to the media. So, yeah, no, Candace didn't have the right to do that. And here is that press release information here on the 2.2 million settlement. And I, specifically selected this case because, like I said, this is more closely aligned to what Candace did when she published Charlie Kirk's medical file on her social media platform to at least 5.8 million people. So, New York Presbyterian has agreed to settle potential violations of the HIPAA rules, specifically to the impermissible disclosure of two patients' protected health information to news media and the lack of appropriate safeguards for protected health information, also known as PHI. Just in case you get the acronym, Candace, and you don't know what it means, PHI means protected health information. You're welcome. The settlement includes not only a monetary payment of $2.2 million, but also a comprehensive corrective action plan that includes 2 years of monitoring. That hospital can be subjected in Utah, could be subjected to not only a fine and a huge settlement, but that medical staff that took that print screenshot illegally and unlawfully without consent and sent it to Candace Owens could not only lose her job, but face some sort of criminal charge as well as civil liability. So let's say Erika Kirk decides to sue Candace Owens LLC, Georgetown Inc., the medical staff that took the print screenshot and sent it to Candace, and the hospital. That's 5 co-defendants right there. She could ask the court to grant her judgment collectively and individually. So let's say there's a $3 million settlement, and the judge decides each person is going to pay $600,000 towards this $3 million settlement. Candace Owens would have to pay it from 3 levels: herself personally, Candace Owens LLC, and Georgetown Inc. Now, tell me how her posting that information was worth any of that. And I'm just giving an example. This is low. 2.2 million, that's low. Charlie Kirk was a high-profile public figure. I mean, Erika Kirk has, whole presidents behind her. I mean, for goodness sake, she received, the Presidential Medal of Freedom on behalf of her husband, posthumous. So if she sued Candace, the hospital, the medical staff, and Candace Owens LLC and Georgetown Inc., her monetary settlement or her judgment would be at least $10 million because of the damage it would do. Releasing that information to at least 5-point-something million people on Candace Owens' YouTube channel. And that's not including all the people that will see this. You have millions more that will watch Candace Owens' videos but may not be subscribed to her channel, which is crazy to me. I don't understand how someone who sensationalizes and creates conspiracy theories has 5-point-something million followers, but whatever. So y'all make sure y'all hit the like button on this damn video and share it. I wish I could get, Erika Kirk's attention. So what I did was, from here, I selected the read the resolution agreement. And this is that PDF file of the resolution agreement. And as you all can see here, what happened was the complaint itself was filed with the Department of Health and Human Services Office for Civil Rights that enforces the federal standards that govern the privacy of individually identifiable health information and the federal standards that govern the security of electronic individually identifiable health information and the federal standards for notification in the case of breach of unsecured protected health information, which in this case would be the hospital who would basically be liable because that medical staff took a picture of it and sent it via email through electronic means to Candace Owens of all people. So this was the representative for the patient. When they filed a complaint, It's no different than an EEO complaint. You file a complaint with HHS, they in turn conduct the investigation, and then they take this matter to the court. Now, this matter was reached through a resolution agreement. There was some sort of agreement settlement done, more than likely an arbitration of some sort, to avoid it going to court. But doesn't mean that that resolution agreement would not carry the same weight as if it were a judgment. They agreed to settle, but it doesn't mean that that settlement would be just overlooked and dismissed. Nope. Decide you're not going to pay that settlement if you want to. Now you're talking about going to court with it. And the judge will not show them any mercy, them being the defendant. The New York and Presbyterian Hospital, NYP, is a covered entity. So I spoke about hospitals, insurance companies, health insurance companies, and pharmacies are considered covered entities, as defined at 45 CFR statute 160.103, and therefore is required to comply with the HIPAA rules. And so there's some background information on here. This is going back to January 27 of 2013. The HHS Office for Civil Rights received a complaint against NYP alleging that on April 28, 2011, NYP impermissibly disclosed PHI to a film crew and the other staff of NY Med, a television program being filmed in the hospital. On May 29, 2013, HHS notified NYP of HHS investigation regarding NYP's compliance with the privacy rule promulgated by HHS pursuant to the administrative simplification provisions of HIPAA of 1996. And then there's a publication there. So basically, the HHS did the investigation, found that NYP was liable for the damages based on their investigation, considering the fact that even though there was a news crew that, most people consider, member of the press, ended up releasing PHI without the patient's consent. And they did not have the authority to do that either. So they were filming for a show. So, of course, the parties agreed to resolve this matter according to the terms and conditions below. And you see some other information here regarding those terms and conditions. The resolution amount being 2.2 mil. A corrective action plan was put in place for the hospital to abide by. Released by HHS. Agreement by released parties. So let's say NYP decides they don't want to pay the settlement. Well, then the patient would have the authority, the legal authority, to file a lawsuit against NYP, not HHS, because NYP is the one that released the damn information when they allowed the press to come in and record for a damn television show. Yep. So this is 11 pages. You guys can read this. And this is the information that people should be aware of. Just because Candace Owens considers herself to be some level of some sort of a investigative journalist, whatever, blah, 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 does not mean that she is completely protected when she releases individually identifiable medical information. If she obtained it illegally, to what she did, and then she decided to publish it without consent, she could be held liable for damages. And that is what I said in my previous video when I talked about this. And as you all can see now, you have a clear, solid case in which the HHS upheld that. And this is going back to 2013. It's the year of our Lord 2025. So this has been in place. This has been some level of I don't want to say precedence, but at least a case in which the language for members of the media, journalists, members of the press, were held responsible for releasing PHI. There was no mistake of who the patient was in that screenshot of the medical file that Candace Owens showed. We clearly saw Charlie Kirk's name and date of birth. No one needed to see that. So I encourage you guys to read and research this information. And as always, hey, I'm here to be challenged. If you want to challenge me on this, you can. But I'm going to have a better legal argument. Trust me when I tell you that. So hopefully Erika Kirk decides to take some action, because this was absolutely deplorable. Candace Owens is not proving a point. No one needed to see that medical information. It did not solve anything beyond what she thinks in her mind is being solved, which is nothing. Candace Owens is not a licensed, certified, trained, educated investigator whatsoever. I don't even consider her to be a good journalist. Not at this point. This is the stuff that she used to do, where she would pull up information, research it, pull up, facts and evidence, documentation that could be, considered to be facts and evidence. But now she's just 100% conspiracy theorist. I'm questioning everything. I'm waging war on Turning Point. Okay. When people start clapping back and then they wage war against you in the court of law with lawsuits, don't go crying victim. You brought that on yourself, Candace Owens. Do you expect a narcissist to really understand the idea of hypocrisy when they can't say hell you what UTC stands for? Candace Owens, you're just being the worst right now, girl. All right, y'all. That's all I have. Thank you so much for tuning in. I know I stuttered a couple times because I'm exhausted. And it's taking me this long to really get situated to be able to do this video. But a shout out to the person that left the comment, because, it was a viable, comment and worthy of me researching further and presenting more information to help you guys understand why I said that Candace Owens could be sued, and what she did was a violation of HIPAA. Now, she's not a covered entity, but she is still bound to maintain individual identifiable medical information. There was no reason to do it without consent. And Erika Kirk would not give her consent to do a damn thing at this point. So I think we can all agree to that. You guys make sure you hit the like button and share this video. And subscribe to the Lady Luck Club. I'm trying to hit 30,000 supporters. If she could get 5.8 million on stupid shit, then clearly the research and the facts and the evidence being presented here in the Lady Luck Club is worthy of a sub. You don't have to like me, but facts are facts, laws are laws, and none of those things care about Candace Owens' feelings. And she's going to continue to find this out the hard way as she continues to delay this defamation lawsuit that the Macrons have had to file against her. Candace, stop delaying that case. Where is your response to the amended complaint? That is what you should be tending to. When I talk about anything else that is of the public's interest, as far as information we need to know, you're not an investigator. And the CIA needs to sue you as well for weaponizing their logo or the likeness of the logo to earn revenue while you mock them at the same time. If you were smart enough to be an investigator, you would have become one. This isn't the way to go. And Charlie Kirk does not deserve this. Leave him alone. You claim to be his friend. Don't demolish and tear down his entire legacy. And let his wife grieve and mourn. At some point, his kids got to grow up and see your videos. You're not even considering them. It's just soulless. And it's evil, Candace. And many, many millions of people are disgusted by you at this point. So, that's all I got, y'all. Hit the like button, share, subscribe, and until the next one, Lady Luck Club out. Deuces.